Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast. This edition we're looking at DWI cases and what's called operations. So in the unreported case of State versus Speranza, the court held a vehicle did not need to be seen in motion to trigger liability under the DWI statute. The defendant here appealed his DWI conviction. The defendant's conviction stemmed from an incident where police responded to a report of an unconscious male in a vehicle at an intersection. The responding officer found defendant asleep in the driver's seat of his car, which was sitting at an intersection with the engine running. The officer was unable to rouse the defendant, forcing him, the officer, and other responding officers to drag defendant out of his vehicle. The defendant eventually came to, telling officer he had come from a friend's house, but did not know where he was. The parties stipulated the defendant was intoxicated when the police found him. The municipal court accordingly convicted the defendant, finding he was operating his car within the meaning of the DWI statute. The defendant appealed to the trial court, which conducted what's called a trial de novo, in which it rejected defendant's argument that he did not operate his car. The trial court held that defendant intended to operate his vehicle because he was sitting in the driver's seat with the engine running. On appeal, the court affirmed defendant's conviction, ruling that a vehicle did not need to be seen in motion to trigger liability under the DWI statute. Instead, it was enough that defendant had the possibility to move their vehicle by sitting in the car with the engine running. So, for more, the bottom line is that, if you pull over, jump into the back seat, and you can just argue, a friend dropped me off and I was keeping warm. For more information on DWI and DWI defenses, visit website njlaws.com. And for representation, contact Ken Vercammen's office in Edison at 732-572-0500. Thank you.